Good afternoon. Welcome to Florida Appeals CLE on preservation of error. Don't wave goodbye, preserving error for appellate review. I'm Shannon Macklin, an appellate lawyer and founder of Florida Appeals. This is the first of what we hope are many CLEs that we plan to host to assist practitioners navigate the appellate world. So if you have any other topics that you think would be helpful for us to cover, please let us know. Today's presentation will be divided into three sections. First, Robert Scavone Jr. will briefly discuss the standards appellate courts apply when assessing error. Robert clerked for Judge Adalberto Jordan at the United States Court of Appeals for the 11th Circuit and at the 3rd District Court of Appeal for Judge Barbara Lagoa. After Robert, former 5th District Court of Appeal Judge William Palmer will explain how to preserve issues for appeal and why a 2014 opinion from the Supreme Court of Florida called Special flipped the burden for showing harmless error and why that opinion likely changed offers of proof. Bill served on the 5th DCA for 18 years and was chief judge of that court from 2007 to 2009. Last, but certainly not least, is Erin Pogue Newell, and she'll discuss motion practice as it relates to preservation. She will cover recent changes to the civil and family law rules dealing with motions for rehearing and when to file your notice of appeal. Erin has traveled the state arguing cases before all of the district courts of appeal, except the 6th DCA, not quite yet. And she has appeared before the United States Court of Appeals for the 11th Circuit. Time permitting, there will be a question and answer period at the end of the program. Please direct your questions to me, Shannon Macklin, in the chat, and we'll get to as many of them as we can. And if we run out of time, please feel free to just email us directly at info@floridaappeals.com, and we'd be happy to help you out. Thank you for joining us. We hope you enjoy the CLE. And now I'll turn the program over to our moderator, Robert Scavone Jr.
Thank you very much, Shannon. And thank you all for joining us. I'm Robert Scavone Jr. And as Shannon mentioned, I will be moderating this presentation. There are a few housekeeping matters I'd like to address before we get started. First, please be sure to remain muted. And second, the presentation contains a lot of case citations. Please don't worry about writing these citations down. As Shannon mentioned, you are going to get a PDF of the PowerPoint in the coming days. All right, we're going to get started. And Bill and Erin, please, if you want to jump in at any time, please feel free to do so. We start with the basics. Generally, you must preserve harmful errors to have a chance at prevailing on appeal. With one exception, which I'll get to in a moment, you must preserve the error. If you don't, it's kind of like the soup guy on Seinfeld. No appellate review for you. So let's review the ways in which courts assess error. There are generally 7 ways appellate courts assess error. Preserved. This is the category most errors fall into. A preserved error may be deemed harmful or harmless, but in either case, the error must have been preserved to get appellate relief. Unpreserved error is generally fatal to appeal, except in cases of fundamental error, which I'll get to in a moment. Harmful error. These errors are, if preserved, are likely to result in a reversal unless the error was harmless. Harmless error review. This is sort of like the even if error. Even if the court erred and assuming the error was preserved, the appellate court will affirm. Invited error. This is what I would call the doomsday error, and I'll explain why in a moment. Fundamental error. This is the one exception to preservation, and it's sort of like an escape hatch of sorts, and it applies even if the error was unpreserved. And then finally, cumulative error. And the idea behind this is that while any one preserved error by itself may not warrant reversal, several taken together might. So I want to quickly review harmless, invited, fundamental, and cumulative error. Harmless error, here the appellant always loses because even though the error was harmful and preserved, it did not vitiate the right to a fair trial. This frequently comes up in cases of the erroneous admission of hearsay, for example. Bill will have more to say about this in his discussion about Special v. West Boca Medical Center.
Robert, I'll add something right now, if you don't mind.
Sure.
I mean, one of the purposes of recognizing harmless error is we like to say you're entitled to a fair trial. You're not entitled to a perfect trial.
Mm-hmm.
So in a simple example, if you have 10 witnesses who all say the light was green in a case, and one of the 10 shouldn't have been allowed to testify to it, the court very well will say there's no reasonable basis on which that would have changed the outcome of the trial, and therefore we're not going to reverse on that basis.
All right, thanks for that, Bill. Invited error. Again, this is what I would call the doomsday error because the appellant always loses. Invited error bars appellate review. And this is true even if the error was fundamental. An appellate court will not reverse where the error was invited. Fundamental error. Maybe the appellant wins, even if the error was not preserved, and that's the key. Section 90.1043 lays out the court's authority to address very serious error, i.e. those that affect the substantial rights of a party. Fundamental error is very rare in the civil context. And I would note that, as I said earlier, fundamental error is waived when the error is invited. And finally, cumulative error. And I can think of this as sort of like a death by 1,000 cuts. Any one error by itself will not result in reversal, but several errors might. This type of argument only works if the errors are preserved and are harmful. And finally, for you folks that practice in federal land, there are two additional errors we wanted to highlight. Plain error, which is similar to fundamental error in state courts. To prevail, the appellant must show prejudice, meaning the error affected a substantive right. And finally, we have structural error. This occurs exclusively in criminal cases, and the DOJ always loses. The main difference between plain error and structural error is that the defendant does not have to show prejudice when the error is structural. All right, folks, that does it for me. I'm going to turn it over to Bill. Welcome in, Bill.
I'm here with you, Robert.
Great. To begin with, can you explain why preservation is so important?
Well, it really goes to the heart of what the role of an appellate court is. The appellate courts are error-correcting courts. They're not there to decide law in the abstract or to decide how they think a case should have come out if they were ruling on it originally. They are there to correct errors of the trial court. And so if they reverse a case, what they're doing generally is they're saying to the trial judge, you made a mistake, it was harmful, and we're going to correct your mistake. Well, it's a little hard to tell a trial judge they've made a mistake that you're correcting if the trial judge wasn't asked to address that issue or that mistake. And so if the court is there to correct errors, they're generally going to say the trial court didn't err if they weren't asked to do something that you're now asking us to reverse them on.
Okay. And I briefly addressed fundamental error. And there are a few examples on the screen. In your experience, Bill, when does this most often come up?
It almost often comes up in the criminal context, usually in a due process or constitutional rights setting. It's very, very rare in civil context. In the 18 years I was on the bench, I don't recall a single case where in a civil case we decided some error was fundamental. It really has to go to the very heart of the case and make it untenable for the decision to stand, even if the error was not preserved. And so you have a couple of examples here in this slide where summary judgment was entered without holding a hearing, or a particularly outrageous closing statement. I can recall one case we had which probably would have met this standard. I don't think it was at issue because I think it was preserved, but it's the kind of error that probably could have met that standard. We had a case, it was a dissolution of marriage case. At the end of the case, the trial judge asked each of the parties to submit a proposed final judgment. They submitted two conflicting final judgments, and the trial judge just signed both of them. They brought this to the attention of the trial judge, and the trial judge didn't change anything. So you had two final judgments inherently in conflict that were both still in play. That's the kind of situation that I think would probably qualify as fundamental error, because there's no way both of them could stand and be enforced because they were inherently in conflict with each other.
All right. And why do we say that this is an exception to preservation?
Going back to the primary focus of the courts being to correct errors, this is one place where you can, in essence, say the court made a mistake, even if it wasn't specifically brought to their attention, because it is so critical and goes to the heart of the case.
Thanks for those examples, Bill. I appreciate that. Now, section 90.104 authorizes judges to make evidentiary rulings. Bill, what are the distinctions between what a lawyer must do when her objection is to the admission of evidence as opposed to the exclusion of evidence?
Well, let's start with those things that are the same. And that is that in both cases, you have to make a timely objection, which we'll talk about a little more, and you have to make a specific objection, which we'll also talk about in a couple minutes. But the one main difference is if you're objecting to evidence which is admitted, you don't have to make an offer of proof because the evidence is already part of the record. The appellate court will be able to see it and review it. But if the evidence is excluded, you need to make an offer so that there's something in the record for the appellate court to look at to determine whether or not what was excluded was erroneous, and if so, whether it was harmful. The appellate court is going to be limited to what's in the record when they're reviewing the case on appeal. So you need to make sure there's something in the record from which the court can determine that this exclusion was indeed an error.
And we've also noted here that the ruling must be definitive. How have appellate courts defined definitive?
I think it often comes up in a context like a motion in limine where the court will make some conditional decision about whether certain evidence should or should not come in. But it's in a context where it's clear that that ruling could change at some point. And so the judge doesn't rule ahead of time that all this evidence is inadmissible, but leaves open the possibility that based on how other evidence comes in, how the case develops, it may or may not ultimately be able to come in. So in that case, the original ruling on the motion in limine is not definitive, it's conditional. And therefore, when the time comes for presenting that evidence, you need to reassert the objection so the court can determine whether those conditions have been met, and then get a definitive ruling to preserve it for appeal.
All right. And in addition to 90.104, there is another source of authority, and that is Rule 1.450. Bill, I'm wondering what you make of the word may in the first sentence of this rule.
Well, there's actually a few mays throughout this rule, and I think it does two things. Number one, I think it recognizes, as we noted with regard to the statute, that you don't always have to present an offer of proof if the substance of the evidence is apparent from the context. So that's one area where you may not have to, and that may be why this is permissive. This also has mays talking about sort of the procedure for how you go about the offer of proof. And since you can do that in a couple of different ways, I think this just gives the trial court some discretion on how they're going to go about handling an offer of proof.
Okay. And on this slide, we provide the steps that one must take to preserve an objection. It has to be timely, has to be a specific objection, and there needs to be an offer of proof. And Aaron is going to discuss an additional requirement for preservation, which is a motion for a hearing that arises in certain contexts. Bill, most lawyers know that a timely objection generally means contemporaneous with the, at the point the objectionable material is being offered. But the case law hasn't really been quite consistent on this. Can you think of situations where there'll be some wiggle room and the appellate court will address the error even if it was not made contemporaneously?
Sure, you may have a situation where there's one question asked that may be marginally objectionable, but you're not sure how it's going to be developed or whether it's going to make much of any difference, and maybe you don't want to flag it right then if that's the case. But within a couple of questions now, they're focusing on that issue more, and it becomes clear that it's objectionable and potentially harmful. And so maybe after 3 or 4 questions, you finally jump in and make the objection. That's probably going to be sufficiently timely for the rule. When you look at the purpose of the rule, it's to put the trial court on notice of the error and given the court a chance to correct the error. And so if you do it relatively soon after the first question, then the court's got an opportunity to correct it. They can advise the jury to disregard, etc. If you wait so long that it's really not something that the court can have a chance to correct, then that's probably not going to meet the standard for timely. It's also a rule in place to prevent a litigant from not challenging an error so they can use it later as a tactical advantage. And so by requiring you to bring it up as soon as reasonably possible, you avoid that game playing that a litigant might get involved in where they think they can use it to their advantage later.
Okay, so you've made your timely objection. Now what? The objection must be specific. Bill, what is the meaning of specific in this context?
It has to be specific enough so the court understands exactly what the basis of your objection is. There are no specific magic words, quote unquote, but it has to be sufficient so that the court knows exactly what the basis of your objection is. Something like for the record or lack of foundation or improper predicate is not enough. So for example, for improper predicate, there may be several reasons why something was an improper predicate, and you think it's improper because of reason A, and it turns out it's not improper because of reason A. There was some other reason for it, but you never brought that to the attention of the trial court. So it goes back again to the whole idea of the appellate court wants to look at whether the trial judge made a mistake, and the mistake has to be based upon what you asked the trial judge to do.
All right, so what about, trying to think of a situation, let's say a lawyer objects to hearsay. And that objection is overruled, but there's another basis for the objection. Will the appellate court deem that error as preserved?
Typically not. In your example, if, for example, it turns out it wasn't hearsay, but the witness wasn't competent to testify about it, or there wasn't a proper foundation, all the trial judge was asked to do in that case by the lawyer was to keep it out on the basis that it was hearsay. The court said, I'm not keeping it out. It's not hearsay. Well, there's no mistake there to be corrected by the appellate court because the trial judge did it correctly in that regard. And if you later say, yes, but he should have kept it out on a different reason, like improper predicate, the response is he was never asked to keep it out on the basis of improper predicate. So he didn't need to analyze that question because the lawyer didn't ask him to keep it out on that basis. So we as an appellate court are not about to tell him that he made a mistake by not keeping it out on that basis.
Right, and sometimes a trial judge will give you a heads up. You'll raise an objection, and the trial judges will say overruled on that basis, and that's usually a clue that there may be something else here that you're missing.
Or alternatively, you might have a trial judge who you'll say objection, and they'll say on what basis to make sure that you have
Right.
a chance to preserve it on the record, or objection hearsay. Okay, which exception to the hearsay rule
Right.
you think applies here?
Yeah.
But it's certainly not the obligation of the trial judge to do that for you. So you ought to be prepared to do that on your own.
Right. And now in nearly all situations in the law, case law usually adds an additional gloss to things, and case law has added a gloss to the preservation requirements. One thing you must remember is to get a timely ruling. Sometimes a judge may forget to rule on objection, and in the heat of the moment, extra credit, by the way, for anyone who gets that musical reference, the lawyer may forget to ask for a ruling. And the bottom line is no ruling, no appeal. So Bill, can you give examples of when this might happen?
I think the most typical example is not such that a trial judge would forget to rule, but it just sort of gets glossed over. So the lawyer asks a question, there's an objection raised, and the judge says, move on. Well, what does that mean? Does move on mean that the objection was sustained? Or does it mean it was not sustained? The appellate court could very well say, we don't see a preserved error here. Where's the ruling that you're objecting to? My ruling is he said move on, but we don't know what move on means. So in that scenario, you may need to say to the trial judge respectfully, Your Honor, does that mean you're sustaining the objection? And typically the trial judge will tell you what it means, and then you've got your definitive ruling that allows you to preserve it for appeal.
Perfect. Now, this one case on this slide also deals with continuing objections. What are some examples you can provide when a lawyer must continue to object in order to preserve error?
I think the key is that unless it is clear on the record that you have a continuing objection, then each time there's a question you object to, you need to raise it. So let's say somebody's asking a question of a witness that you think is improper because it goes to reputation or prior bad acts, and the judge sustains it, and now there's another question asked about another prior bad act. Well, I don't think you can assume that because the court ruled against you on the first one that you don't have to object the second time, because the appellate court may very well say, well, you never objected to the second one, so we can't review that. On the other hand, if you make it clear, you say, ask the trial judge, Your Honor, can I have a continuing objections to any questions about prior bad act, whatever? And the court indicates that, yes, they recognize it's a continuing objection. Then you've got it on the record, and it should be preserved for any questions that ask about prior bad acts.
Okay. And the final step is to make an offer of proof, which some people refer to as a proffer. And there are two ways that this can be done. One is with an attorney narrative, where the attorney essentially summarizes what the witness will testify to or what the evidence would show. And the second way is by a Q&A with the witness outside the presence of the jury. And here, essentially, the witness takes the stand and you conduct your examination, and that's the proffer. Of these two ways, Bill, what do you think there's a preferred method?
I think it's very fact specific. I think in some cases one makes more sense. In other cases, the other makes more sense. Part of it may be tied to how simple or complex or nuanced the issue is as to why the evidence or the witness is being excluded. Sometimes you can explain in a sentence or two what your position is, and that pretty well makes it clear. In other cases, maybe you need to have the exact testimony of the witness for the court to be able to make a determination whether it was error to exclude that testimony. Some of it may come down to practicality, how much time it's going to take, whether the judge is going to be predisposed to allow a more detailed offer of proof, or whether it makes more sense to do it in a more streamlined fashion.
Okay. What about in a case where it's like a photograph or physical evidence that you're trying to admit?
If it's a document, you always need to have it marked for identification so that the trial court or the appellate court can ultimately see what the document shows. Since the appellate court can only look at what's in the record, unless you've at least identified it so that it's put into the record, the appellate court's not going to look at it because that's an easy case of being able to get it into the record for them to look at down the road.
All right. Bill, at the top, I briefly mentioned Special v. West Boca. In this case is important because it really has an impact, or could have an impact, on offers of proof or proffers. The important points are that Special shifted the burden, and now the appellee, as the beneficiary of the error, needs to show that the error was harmless in order to obtain affirmance. Bill, can you just explain what Special means in the practical sense?
With regard to offers of proof, it seems to me, since Special now says the burden of proving that it's harmful is on the other side, the beneficiary of the error, it seems to me that what a party now has to show in an offer of proof is that it was error to keep it out. I don't think they have the burden to also prove that it was harmful error, because that burden has been shifted by Special. Before Special, there are a lot of cases where the language basically says there was no offer of proof, and therefore we can't determine if it was error, and if it was error, was it harmful? And I think that was the standard before Special, but it seems to me now that Special is in place, it's only the first of those two that should be in play. And what that would say about an offer of proof is you may be able to have a shorter offer of proof to establish that it's an error than a more detailed proof, which you would have had to do in the past to show that it was harmful error. And you might also, frankly, be put in a position where you help the other side meet their burden of showing it was harmful by putting in too much offer of proof, or too detailed an offer of proof, which the other side could then use to show why it was harmful.
So then, like, in a tactical sense, you're basically saying that the different options would be to give sort of a bare bones offer of proof to preserve the appeal, but don't go too far with it.
I think theoretically that's true, but as we'll see on the next slide, as a practical matter, you may still need to do the more detailed offer of proof.
Yeah, that brings up a case that came out of the 6th DCA back in February called Waive State. And this opinion arguably conflicts with special. Bill, are you able to reconcile special with May?
Well, May is a case where they apparently conclude both that there is no error, well, or that I should say that based upon the lack of an offer of proof, they can't determine whether there was an error at all. And if so, whether the error was harmful. The first prong of that would have been dispositive of the case. They wouldn't have had to get to the second prong of whether it was harmful or not. So I think this may be picked up on some language from older cases from before special. And there's no indication that special was presented to the court that I know of. They don't reference it in the opinion. And so the second part of that, which seems to continue to say there's a burden to show that it's harmful, may be dicta in this case because they never really had to get to that piece of it. And it may be that in a case where special is specifically argued, that they would recognize this shift of burden and how it affects the offer of proof.
Okay. On this slide, we provide the steps to make an adequate offer of proof. Bill, where do you typically see lawyers making mistakes with offers of proof?
Well, let's talk about it. Obviously, you want to do it outside the presence of the jury. You want to make it as specific as you possibly can. You want to explain what the purpose of it is. You just want to be detailed in your offer of proof so the judge understands exactly why you think the objection should not have been sustained or why you should be able to get the information in.
Okay.
And if it's a document, as I mentioned earlier, you absolutely have to get it identified and get it into the court record.
Right, and we note on this slide that it is error for a trial court to refuse to allow a proffer. Bill, do you think what if the judge just absolutely insists? Is there any kind of remedy?
I think there is a remedy because if you have asked the court for an offer of proof and the court would not allow you to do it, an appellate court would be disinclined to reject your appeal on the basis that you didn't provide an offer of proof because you didn't have the chance to do that. In that case, one of your issues on appeal would be the trial court made an error by not allowing you to make your offer of proof.
Mm-hmm.
And that would be an error, presumably as a matter of law. And that may be one of those situations there. And then you don't have to show that it's harmful because that's not your burden now. You showed that there was an error. As a practical matter, if the judge refuses to do it, I think you need to respectfully ask them to allow you to do it, to tell them you need this as a record for purposes of appeal. It doesn't have to disrupt the proceedings. It can be done after after hours. I've seen judges who basically say, since it's an offer of proof and it's not actually going into evidence, I don't even need to be here. I'll leave, and if you want to put it on the record after I'm gone, go ahead and do it so that it's minimally disruptive to the process. So I think you try and tell the trial judge you need it for potential appeal, and if they still refuse, then you've got an independent issue for appeal.
All right, Bill. Well, thank you very much for walking us through those steps. I appreciate it. And
Okay.
I wanted to bring Aaron in now for a discussion. Hello.
Good afternoon.
Good afternoon. We're going to have a discussion here about motions for new trial or rehearing. We're focusing on rehearing. To begin with, we look at the rules dealing with the motions for rehearing, which are on the screen, 1.530 and 12.530 for family law. Aaron, can you give examples of why these rules are deemed exceptions to finality?
Sure. I think any discussion about motions for new trial and rehearing really has to start with the basics that, under the present rules, after rendition of a final judgment, the trial court retains jurisdiction for only this 15-day period. And during that time, that's when you can move for new trial or rehearing under these rules that you see on the screen. But after those 15 days, the trial court loses jurisdiction. Then that's opportunity to alter or amend or to reopen the final judgment is lost. The only really jurisdiction the trial court has at that point is to enforce the judgment, or if there's been a reservation, to rule on some other issue. At that point, it's really not a final judgment yet anyway. But then really the only other opportunity you have except for an appeal is Rule 1.540B, which is a whole different sort of animal that we're not going to cover today. But that is why when you're thinking about these rules, you really have to understand that after this 15-day period, you have finality and you don't have the opportunity to get into that judgment anymore. One other thing I wanted to mention, I guess, on this is that bullet point you see about interlocutory rulings, right? So it's really important to understand that there is a difference between a non-final ruling and a final ruling. A good example, especially in family law cases, people will see this often where there's been a reservation on some issue, whether it's like child support or something like that. The court may handle a certain part of the issues first and then reserve to have the parties come back and present on this reserved issue. So what you really have is an interlocutory or non-final ruling. And the court has inherent authority at any time up until the rendition of a final order or judgment to go back and reconsider its own, interlocutory rulings. So that's something to keep in mind.
Great. Now, as many of you know, the Florida Supreme Court amended 1.530 and 12.530 in 2022, and the court added the preservation requirement. So this is why we say this is another step in preservation. Aaron, can you talk a little bit about what the reasons for the amendment were?
Sure. So we have the citation there, and the opinion really does try to explain that the purpose of the amendment was to clarify. The court wanted to clarify that filing a motion for rehearing is required to preserve an objection to insufficient trial court findings in a final judgment or order. I think in actual practice, it did create maybe some more confusion amongst practitioners about, well, what exactly is insufficient trial court findings, and do I really have to file this motion for rehearing now if we're thinking about an appeal? So that will lead us into, well, I guess go ahead into the next slide. We can talk about the court commentary.
Yeah, I did want to just ask one quick question.
Sure.
You said that the rule was done for clarification. But did it cause confusion among litigators?
Yeah, so in the family law especially, there was a split of authority amongst the DCAs about whether the appellant had to have moved for rehearing to apprise the trial court, especially when you had findings under the requirements in Chapter 61. You have a lot of different best interests of the child's requirements. You have the alimony, all of these elements that the trial court is required to consider. So a lot of times on appeal, you would have the party that's challenging the order saying, well, the court, this is insufficient. They didn't even touch upon the required things. And, the third and the fifth district courts of appeal came out very strongly and said, look, you've got to raise this in a motion for rehearing, or we're not going to consider it. It's not preserved. The other district courts of appeal had some differences, and some case law was developing and people were taking sides on it. So, that is where the clarification came in. But I do think it did still it wasn't as clarifying as perhaps the Supreme Court had wanted it to be.
The court also added commentary to the
Mm-hmm.
rules. Can you explain what this means in practice?
Yeah. So people forget and maybe not even realize, especially in the beginning of your practice, that there are any number of reasons that you may either want or need to move for rehearing or for new trial. This rule is extremely broad. It actually gives the trial court the broadest amount of authority to even open it up on its own initiative during that 15-day period for any reason. That's direct language out of the rule. So, it's not only a very limited, you have to have insufficient trial court findings. It's any other reason. You're always allowed to file this motion as long as it's timely and authorized. So, the issue about preserving for an issue for appellate review, it's not meant to limit your ability to file the motion.
And on this slide, we show that the court re-amended both rules just recently, just back on April 27th. And that rule became effective that day. And we show you the struck through text and then the new text. Aaron, what was the reason for further clarification of this rule?
So the court explains that it's not necessarily the sufficiency of the trial court's findings now. We want to make it very clear that it's the failure of a trial court to make required findings of fact. And so that kind of goes back to the example I was mentioning about, in the statute and family law, there are a lot of factors that a trial court's required to consider. And there are examples of this throughout, many statutes, many rules where the trial court is required to make findings of fact. So, this rule is intended to clarify that for to preserve for appeal, a challenge of the trial court to make those required findings of fact, you're going to have to raise the issue in a motion for rehearing.
Then do you think it's good practice to file a motion for rehearing and, in all situations, just out of an abundance of caution?
Of course, I think the abundance of caution phrase is an appellate attorney's favorite friend. We pretty much do everything out of an abundance of caution. But, in reality, we understand and we all know, especially solo and small practitioners, it's not realistic in every single case to be filing a motion for rehearing. You might not have the time or the resources. So I would say your real key to making that decision is to look back and see, okay, what law am I traveling under here? Like, what is the actual requirements, and are any of them missing? Because if that's the situation you have, you don't want to just sit back and say, oh, well, this means I'm going to get an appeal. This means I'm going to win an appeal. Not anymore. If you see that clearly and you see that there are required fact findings that the trial court didn't make, you need to file that motion for a hearing now, especially under this 2023 amendment, because you could and very much will lose that issue on appeal for failure to preserve it.
And on this slide, we note that some of the comments that the court made in the recent amendment, and it noted that the rule is applicable to all orders. Aaron, what does that language mean in practice?
So this is one of the most interesting things I think about this rule, and it's something that already we've been discussing with various practitioners. Is so why did they take out the in the final judgment? Why did they strike that out? And why is this applicable to all orders and not just final judgments? And I think that we have to remember that this is a exception to finality. There's nothing has changed that about 1.530. However, there are a lot of non-final orders. In my experienced attorney's fees are a really good example, because a lot of times the judge will bifurcate the decision of the entitlement from then the decision of the reasonable amount of fees if they're awarded. So if you see in your entitlement order, which is technically not a final judgment yet, if you see in that it's missing your required fact findings, you do need to go ahead and file that motion for reconsideration / rehearing. So that's it. Once, I think the way I'm interpreting this rule amendment is that the court really wants those motions to be filed, even if it's not a final judgment.
Okay. And on this slide, we just kind of recap the preservation requirements under the new rule.
Yeah, and I think this is the one to screenshot if you want a fast, like a checklist, when you get your order in. Like, you need to preserve it where the trial court fails to make a required finding of fact, and this applies to all orders, not just final judgments.
Yeah.
So that's your kind of go-to checklist.
Got it. Timing is everything. And as you mentioned earlier, Aaron, that the 15-day deadline is jurisdictional.
Yep. Yeah, so if you actually look, I mean, there's a lot of questions about motions for extensions of time and things, and it's interesting because in the appellate court, there's a mechanism for rehearing after you get an opinion, and that is extendable. But under 1.530, it is not. And actually, if you look at Rule 1.090, which deals with timing, the exception is written right there. The court may not extend the time for making a motion for rehearing or new trial. So it's very clear that this is a jurisdictional thing, that you're not going to be able to get to the 15th day and say, oops, my bad, but I can just get an extension of time. And that's not how it's going to work. So the court does really lose jurisdiction after that 15-day window.
Yeah, and this is another important timing is everything point. Aaron, why won't a motion for rehearing on a non-final order toll the time to file your notice of appeal?
Right, so the language is important in the appellate rule, which you see on the top there. Authorized and timely motions for rehearing toll the time for filing a notice of appeal. So you have a situation with a final order, you know you need to file that motion for rehearing, and you do so. So the appellate rules give the trial court time to look into it, and it essentially tolls your time to file your notice of appeal. This does not happen with non-final orders. And a lot of non-final orders are appealable under Rule 9.130. So it's going to be very important for people in practice. If you have your non-final order and it's lacking findings and you feel like maybe it's on jurisdiction, right? Personal jurisdiction, the court's exercise jurisdiction, and you don't see the findings that need to be in there, you want to file your motion for rehearing for sure, or reconsideration, because now we have this amendment that seems to require it for preservation, but you also want to file your notice of appeal timely, which is within 30 days. If you get into a situation where they're overlapping, the appellate court's not going to deem your motion for rehearing waived anymore. That used to be in the rules, it's not anymore. So, your best case scenario is do not expect the appellate court to treat these motions for reconsideration / rehearing as if they are authorized and timely. You should expect that you're going to have to file your notice of appeal within 30 days.
Got it.
Yeah.
And here we provide just a few examples of how the rule was almost in action. These cases are illustrations of how the DCAs, how they were taking the amendments, the 2022 amendments, very seriously.
That's right. And I like to highlight McGill because it's a family law case in the second, which is one of those DCAs that was in conflict with the third and fifth in family law. But the second DCA is pretty much said, look, now that the rule has been amended, we are requiring motions for rehearing. And they're all, talking about it and considering it in line really with what the 2023 amendment is. So it's really being applied where there's a lack of required fact findings. I think that will continue.
All right. And here are situations where the motion is unnecessary. Aaron, what does this mean in practice?
And these subsection of the rules have been here through these amendments. This is nothing new. And the real thing to think about is who is the finder of fact, right? So these are where you're in a non-jury action or the action's been tried by the court. The judge is the fact finder. So that necessity of apprising the trial judge over again by way of a motion for rehearing is perhaps not as important to preserve. So that just makes that distinction of it being a non-jury action or, the court that's hearing the case without a jury.
And we discussed earlier that there may be situations where seeking more sufficient findings might be required, not by the new rules or the amended rules, but by specific statutes. And we provide an example here with the award of fees. Aaron, are there any other examples you can think of where that might come into play?
For sure. There's examples across the board. Anywhere the trial court is required to consider factors, which happens, I think we can all think of many examples. Kind of a hot topic one could be the new summary judgment rule, right? So 1.510 now requires the court to make those findings on the record. So that's a good one that has kind of been a topic of discussion where if the order is missing that or the court hasn't articulated, its reasoning on the record, that's going to be an issue you need to bring up in a motion for rehearing or reconsideration in order to have that issue on appeal.
Okay. And in this situation, we talk about where a court doesn't really state a basis for its decision. What happens in these cases, Aaron? What does a DCA typically do when the findings are not sufficient?
Right. So as the first district kind of makes a very good job of explaining in this particular case, when the appellate court doesn't have enough on the record to be able to review the case, to review the decision, they are likely to remand the decision back to the trial court and tell the trial court, you need to clarify or make the necessary findings. Now, it's interesting with this new amendment, the 2023 amendment, it puts more onus, I think, on the challenging party to recognize this before you get to appeal and to say, look, this is missing these findings. There's a chance now that in cases like this, the appellate court might say to the appellant, well, you didn't file your motion for rehearing, so, this could be problematic for appellants. I do want to mention for appellees, because we do win sometimes, right? And it's great when we win, and we don't want to get reversed on appeal. So if you have your order that you've won for your client, everyone's, elated, but you see that there's a little something off, right? The court didn't really talk about this. Instead of stepping back and saying, well, I don't want to rock the boat, we won, I'm afraid to bring this up because the trial court might change its mind or whatever, just be aware that you might be taking a risk in that regard. It may be the better practice to alert the court to the fact. That's a tactical decision that you make, but it's definitely something that you want to be aware of.
All right. Well, we're running short on time, but I know that you wanted to highlight Fitchner. What are the important takeaways from this case?
Well, Fitchner is great because it essentially tells trial attorneys, look, 1.530 is so broad that you can even use it if you've caused an error or failed to bring something up. If you realize that was done, bring it up, try to use this mechanism as a way to get it in. Now, the first district was very careful to say, look, trial judges aren't required to consider these new issues, but they can. And so that's the great thing about Rule 1.530. It's not really an exception to preservation, but it's a way to get that extra issue peppered in before you really have that hard final ruling.
All right. And here we just quickly highlight probably the most important piece of preservation, because even if you followed all the steps we went through today, if you missed the deadline, you're out of luck. Aaron, are you aware of any situation in the civil context where an appellate court would excuse the missed deadline?
There is no situation. Nope, it's jurisdictional. So you got to keep track of that order once it reaches finality. That's your ticket. And if you're in doubt about whether you have a final order or not, always err on the side of caution. As you say, our favorite phrase, an abundance of caution. You want to go ahead and file that notice of appeal.
Great. All right. Well, thank you very much, Aaron.
Thank you.
All right. And I wanted to bring Shannon back in for a moment.
Sure, thank you, Robert. We do have a couple questions in the chat. I think both of them are likely directed to Aaron because they have to do with this issue regarding the motion for rehearing and these recent amendments. And the question is do the 2022 and 2023 amendments regarding rehearing, do those apply retroactively? In other words, are these in effect immediately upon their issuance?
Yes. So as far as them being effective immediately, that is accurate. And the Florida Supreme Court does say that. If you, want to go back and look, the slides do have the actual opinions where the Florida Supreme Court is enacting these, and they both, in both cases, the 2022 and 2023, are effective immediately. Now, in terms of them being retroactive, from what I've seen, the answer is no. So if you have a final judgment, and at this point, let me see, April 27th was when the 2023 order came out. So I'm not, we're, how many days out will we be? I think like 12 or 13 days from the date that the 2023 amendment came out. I'm going to tell you right now, file your motion for rehearing. If you're in that situation, just assume that 2023 amendment applies to you, even though technically, arguably, just file it. Any final order or just regular order that has come out after April 27th, which is the date of the 2023 amendment, is going to be applicable.
Yes, I agree. It's much better to be safe than sorry. So file those motions.
Let me add, Shannon, as well. It wouldn't be retroactive in the sense that if you didn't do it on a case that was pending before that, that's now on appeal, that it's going to be applicable, but then you're going to have to revert to what the case law is. And in certain of the DCAs that you would still have that requirement because of the case law is separate and apart from the rule.
That's correct. Yep.
Exactly. All right. Well, thank you. I think that we've run out of time as far as the questions go. But again, if anybody has any specific appellate questions, please feel free to email us at info@floridaappeals.com. And also, I just wanted to let everyone know that we did not realize that our Zoom room was capped at 100 participants. And so others weren't able to actually get on the Zoom right now, but we wanted to make sure that everyone knows and to please pass on the word, and we will through email, that we've recorded the Zoom and we'll be sending out a recording to everyone who registered. So everyone can listen to the CLE at their leisure and then be able to obtain the appellate CLE credit for it. And then also, as Robert mentioned, we'll send you the PDF of the PowerPoint as well. Thank you for joining us and have a great day.